On this video, we're going to analyze question 3 from the February 2008 California bar exam. It is a question involving crimes and criminal procedure. The question reads as follows. Dan's neighborhood was overrun by two gangs, the Reds and the Blues. Vic, one of the Reds, tried to recruit Dan to join his gang. When Dan refused, Vic said he couldn't be responsible for Dan's safety. New paragraph. After threatening Dan for several weeks, Vic backed Dan into an alley, showed him a knife, and said, quote, "Think carefully about your decision. Your deadline is coming fast," unquote. Dan was terrified. He began carrying a gun for protection. A week later, Dan saw Vic walking with his hand under his jacket. Afraid that Vic might be about to stab him, Dan shot and killed Vic. New paragraph. Dan was arrested and put in jail. After his arraignment on a charge of murder, an attorney was appointed for him by the court. Dan then received a visitor who identified himself as Sid, a member of the Blues. Sid said the Blues wanted to help Dan and had hired him a better lawyer. Sid said the lawyer wanted Dan to tell Sid exactly how the killing had occurred, so the lawyer could help Dan. Dan told Sid that he had shot Vic to end the harassment. Dan later learned that Sid was actually a police informant who had been instructed beforehand by the police to try to get information from Dan. There are two calls to the question. Number one, may Dan successfully move to exclude his statement to Sid under the 5th and or 6th Amendment to the U.S. Constitution? And number two, can Dan be convicted of murder or any lesser included offense? We begin with the first call. Can Dan exclude the statements made to Sid under the 5th Amendment? Well, the 5th Amendment, first of all, is applied to the states, and spell it out completely. It's applied to the states through the Due Process Clause of the 14th Amendment. Then say what the 5th Amendment provides. It prohibits violations of Miranda, and it prohibits compelled testimony. Applying the rule, there are no Miranda issues in this case because the Miranda rights end with the arraignment. The Miranda rights begin when there's custodial, when a person is in custody. If they are interrogated while in custody, they have the Miranda rights apply. But the Miranda rights end and the 6th Amendment rights begin when the first court appearance occurs, and that's usually at the arraignment. And so in our case, we have no Miranda issues because this interrogation occurred after Dan was arraigned. Next, the voluntary statement. The 5th Amendment prohibits involuntary statements, and the rule is that the statement must be voluntary. And so what the system does is to define what you mean by a voluntary statement. And the answer is that the voluntary statement is one which is the free and rational choice of the defendant under the totality of the circumstances. So this is the definition of a voluntary statement. Was Dan's statement voluntary? Well, Dan's statement was not a free and rational choice because Dan did not choose to confess. Dan thought he was talking to his own lawyer's agent, not to the police. So this is not a free and rational choice under the totality of the circumstances. The circumstances which are listed here are circumstances such as the defendant's age, the defendant's intelligence, the defendant's familiarity with the criminal justice system, whether or not the defendant has been held without food, water, whether or not the defendant has been held for a long time incommunicado, isolated from other people, trickery, violation of any constitutional rights. Well, these are all and other are circumstances which are taken into account in deciding whether or not the defendant's confession was a free and rational choice of the defendant. But in this case, we don't have to even go to all these circumstances, because it's clear that Dan did not choose to confess to the police. Dan thought Dan was talking to Dan's own lawyer or an agent of his lawyer. And so the statement was not the free and rational choice, and therefore it was not voluntary, and the conclusion is it should be excluded. Next, we are asked if the statement can be excluded under the Sixth Amendment. Now, the Sixth Amendment rule, first of all, applies to the states through the Due Process Clause of the 14th Amendment. And what does it provide? It provides a right to counsel, actually the right to assistance of counsel at all critical stages of the proceedings. Now, this Sixth Amendment right begins at the first court hearing, which is usually the arraignment. Application here, Dan had already been arraigned, therefore his Sixth Amendment rights apply. Fifth Amendment do not. The Miranda rights do not apply. But the Sixth Amendment does. Secondly, Dan clearly was interrogated by Sid. He was interrogated by the state because Sid was acting on behalf of the state, because the police had asked Sid to try to get information from Dan. So this is an interrogation by a police agent, and that is a critical stage of the proceeding. You can apply Messiah directly to this. You recall that in Messiah, after Messiah had been arraigned, a police agent with a wiretap attached to his body had a conversation in which the police, in effect, interrogated Messiah without his attorney being present. And the court said interrogation is a critical stage of the proceeding, and that the person has a right to have their counsel present, and a secret interrogation by the police is an interrogation without counsel present, violates Messiah, violates Sixth Amendment. The statement is excluded. Well, we obviously have exactly the same situation here by analogy. That is, if we apply Messiah, instead of there being a police officer with a wiretap, this was an agent, an undercover agent, in effect, sent by the police to interrogate Dan. And therefore, Dan is being interrogated without his lawyer present, violation of Messiah. Conclusion, statement should be excluded. Next, we are asked, can Dan be convicted of murder or any lesser included offense? Murder is defined as homicide with malice without excuse or justification or mitigation. Homicide is the killing of one person by another, and that's given in the facts that Dan killed Vic. Malice can be found in one of these four ways, and only these four ways: intent to kill, intent to inflict great bodily harm, wanton reckless conduct, felony murder rule. In our case, intent to kill is the one which is applicable. Here, you could use and should use the deadly weapon doctrine. The deadly weapon doctrine says that if a defendant used a deadly weapon, the jury is permitted to infer from that that the defendant intended to kill. On that basis, we can find intent to kill here. So we have homicide by Dan, malice of Dan. How about excuse? Dan does not have either of these excuses because Dan is not an infant and Dan does not claim insanity. Justifications. There are only two: public authority and the privileges. Dan had no public authority, but Dan is going to claim the privileges of the privilege of self-defense. So we're going to have to look at that much more carefully. And finally, please note that excuse and justification, if they can be established, are complete defenses to common law murder, whereas mitigation is like a partial defense. It will reduce what would have been common law murder down to voluntary manslaughter if you have one of these. We do not have heat of passion. We do not have diminished capacity on these facts. But Dan might claim that even if Dan does not completely have the privilege of self-defense, that Dan has the imperfect privilege where he almost had self-defense, and therefore the crime should be mitigated to voluntary manslaughter. So we have to look to see if Dan has the total defense of privilege or if Dan has the partial defense of the imperfect privilege. Let's look at those. Now, from here, you see the privileges. There are three of them: self-defense, defense of others, prevention of crime. Now, in all three cases here, the excuse, justification, mitigation, the burden is on the defendant to prove these affirmative defenses. Some jurisdictions, insanity is placed on the prosecution to prove that the person was sane. In other jurisdictions, the burden is on the defendant to prove that the defendant was insane. But except for that one, all of these are affirmative defenses, and the defendant has the burden of proof, and the burden of proof is the preponderance of the evidence, not clear and convincing, not beyond a reasonable doubt, but preponderance. In our case, if Dan is going to claim privilege of self-defense, well, let's look at that more carefully. Here you see, again, the statement that Dan has the burden of proof with preponderance of the evidence to prove self-defense. Self-defense has these elements. So Dan has to prove that Dan reasonably believed that deadly force was necessary to prevent immediate great bodily harm or death to himself. On our facts, we know what happened. Dan had been threatened several times, and in your answer, you need to point out specifically what those threats were, each and every one of them. Don't just say Dan was threatened. And with all of those threats in the background, Dan then saw Vic walking with his hand under his jacket, apparently where the knife had been before, but we're not sure of that. So is that enough for Dan to reasonably believe that deadly force was necessary to prevent immediate great bodily harm or death? And you can see that I'm not so sure he should reasonably believe that, and the immediacy is also open to question. We don't know how far away Vic was. If Vic was so close that Vic could have injured Dan with a knife, or if Vic was so many feet away that that was not a reality. In either case, the point is that Dan has the burden of proving the affirmative defense, and on the facts we've given, Dan has not proved the immediacy or maybe the reasonableness of his belief that deadly force may be necessary, but the immediacy is the most critical one, and Dan does not have the proof on that. Therefore, Dan would lose his self-defense argument. Dan might say over here that if I do not have the privilege of self-defense, which is a complete defense, at least I have an imperfect defense, imperfect privilege. Now, the imperfect privilege occurs where the defendant has a mistaken belief that the privilege exists. and the jury believes that the person acted on the basis of that mistake, and the mistake was not reasonable enough to meet these standards up here. But the burden of proof, again, is on Dan to prove that he acted out of this mistaken belief, and that the mistake was that he just didn't wait long enough. It wasn't that he just wanted to kill the guy. But on these facts, defendant has the burden of proof, and once again, Dan has not presented sufficient evidence to convince a jury with the preponderance of the evidence that he really didn't want to kill the guy particularly, but he acted to prevent what he thought was immediate great bodily harm or death. So Dan would lose both of those arguments, and therefore Dan could be convicted of murder. Now, one last thing I want to mention before we end this video, and that is that I've gone through the video efficiently, but I want you to be sure to understand that these problems are heavily fact-oriented. And if you just kind of summarize your facts saying, well, here Dan was threatened, well, they'll give you a 50 for that, okay? But if you explain that Dan had been threatened on several occasions, it says here that Vic told Dan he couldn't be responsible for his safety, and it says furthermore, after threatening Dan for several more weeks, then finally Vic backed Dan into an alley, showed him a knife, and said, think carefully about your decision. Your deadline is coming fast. Now, you need to specifically write out each of those. And I know you may feel like, the grader knows that already, but if you want the points, write it down there, okay? Act like you're talking to a jury, and you explain how Dan was threatened. You'll get a lot of points for that. So with that in mind, then, Dan has the burden of proving either the self-defense or the imperfect self-defense, and on the facts that we have, he cannot prove that, and therefore Dan will lose, and Dan can be convicted of common law murder. And that's the end of this tape.